get this underway. I apologize for starting a little bit late. We were something of a late arriving crowd. It was a little bit difficult to process you through the doors. To start with, I want to welcome everyone, even those of you who let us know on the way in or in previous communications. You're not entirely pleased to be here. We always recognize your right to disagree with the judgments that we make in what we believe is the best interest of your children. You never have to agree with us. And I invite those of you who have strong objections to contact me and we'll sit down and talk it through a little bit more. But I do want you to understand at least how we see this. We believe that as a school, especially as a Catholic school, we have not just the right but the obligation to communicate with you as fully as we can about the kinds of choices that your children, our students, make. And that the more often we communicate, the better the chance is that we're going to prevent them from making unhealthy and perhaps legally entangling or dangerous decisions. If you feel that we've gone beyond our reach here, I respect and disagree, but I'm more than happy to sit down with you and talk about it. This comes out of our clear knowledge, a long history, that assures us that unfortunately rituals of passage like proms often have no place in spite of everybody's best intentions. And we all think it can't happen to us or to our children. History, including history of us and prep, indicates differently. Our speaker tonight is Scott Highland from Campbell, Edwards, and Conroy. This firm, as part of its pro bono commitment to the public, has taken on the special responsibility for talking to parents about the issue of post-liability. For us, that's only one part of the concern about kids safely complete the school year or complete their time. And also, we will be meeting with the seniors for the annual Please Don't Ruin It at the Last Possible Moment meeting. But it's necessary every year. It's necessary in part because we will say to them, it's a more turbulent transition than they sometimes realize. And if it were as simple as locking up the usual suspects so that they wouldn't get themselves into trouble, we would do that. But very often, in that time period, nurses get in trouble for the first time. Because in some cases, they've spent the last third of their life in this school, and the bright ones are beginning to realize that they've got this act found now, and wonder whether they'll be as strong at UMass or at MIT or at University of Florida, wherever they're going on to next. And so again, it is our intention always to work with you, recognizing that we will never agree 100% of the time. And those of you who have some concerns about this as an overreaching offer, as I said, I welcome you to contact me directly so that we can talk about it in more detail. Having said that, I know that you're going to welcome our guests and give them your full attention. Thanks, guys.
Thank you. Thanks for having me. Thanks for coming here tonight. My name is Scott Highland. I'm from the firm of Campbell, Edwards, and Conroy. And I'm here to talk to you tonight about social host liability. That is liability, both civil and criminal, for providing alcohol or supplying alcohol to underage children. We give this talk throughout the Commonwealth. Sometimes to groups as small as 5 or 10 parents. It's great to see this big of a group. I like to start the talk about social host liability with a story that helps change the law in Massachusetts to bring it to the current, to what the current criminal statute is in Massachusetts. It all started here at this home down in Cohasset in the summer of 1996. This home is owned by a businessman named John Lennon, and in 1996, Mr. Lennon had 2 of his children graduating from school. His daughter was graduating from college, and his son was graduating from high school at Thayer Academy down on the South Shore. His daughters and her friends were obviously 21 years old enough to drink. His son and his son's friends were 18 years old and not old enough to drink. And Mr. Lennon threw a party. He didn't supply any alcohol to any minors. but he didn't really stop them from drinking either. What he did was he put out 2 kegs of alcohol, a bunch of those red Solo cups, and he let what happened happen. And of course, we know what happened. 18-year-old kids, being 18-year-olds, saw that there was alcohol to be had, and they drank it. Unfortunately, at the end of the party, late that night, one of Mr. Lennon's son's friends, by the name of Gregory Smith, at the time 18 years old, got into his car, tried to drive home, didn't make it, crashed his car, and he died at the age of 18 with his whole life in front of him. And so the authorities investigated it, found out, of course, that he was inebriated when he crashed his car, and they wanted to know, where did he get this alcohol? And they did some interviewing and they figured it out. And so they brought charges against Mr. Lennon under the current social host law in 1996. And of course, Mr. Smith's parents, quite unhappy with what had happened to their son, brought a civil action against Mr. Lennon alleging wrongful death and negligence. And the statute at the time provided that if you provided alcohol or supplied alcohol to someone who was under 18, you were criminally liable. And Mr. Lennon argued, well, I didn't do that. I didn't actually give any alcohol to anybody, so I cannot be found guilty. And he was correct. He was found not guilty on all of those charges. However, the civil case was settled for a confidential amount. I don't know the amount. My firm wasn't involved in the case, but I can assure you that it was probably a lot of money, given that an 18-year-old had lost his life. And I work on these kinds of cases all the time. I can tell you that as a lawyer defending one of these cases, you don't want to be at trial with the jury, an enraged jury, asking them what compensation is due to a family who has lost their son. So it probably settled for a lot of money, and perhaps using some of that money, the Smith family lobbied our legislature to change the law. And they wanted a more robust statute that would prevent Mr. Lennon and people like him from allowing minors to drink alcohol, even if they didn't provide it to them. And they were successful. In the year 2000, Governor Cellucci signed into law a much more robust statute, the current statute that we have now. Mass General Law, Chapter 138, Section 34. And this is what it says. It says, whoever, and that's an important word, as you'll see in a moment, whoever furnishes alcohol to a person under 21 years of age shall be punished by a fine of up to $2,000 and up to a year in jail. The important change to the law in 2000 was the word furnish. Furnish now means supply, give, provide, or importantly, allow to possess alcoholic beverages on premises that you own or control. And that's the current law in Massachusetts. That's the criminal law, and that's the law to which you will be held civilly also. So what does that mean? Well, certainly people like Mr. Lennon, if you just put alcohol out there, you know that it's being consumed by minors and you don't do anything to stop it, then of course you're allowing minors to drink. It can be on property that you own at your house. If you rent an apartment, if you take a hotel room out for the night, if you rent a banquet hall, any of those things, you control that property and you can be held liable under this statute. So that's law in Massachusetts. This is a map of social host laws across the country. Only the states that are in white, those are the only states that don't have a social host law. The rest of them have various levels at the state level, municipal ordinances, common law, those kinds of things. So this is the trend. Massachusetts law is pretty much in the middle. Some laws have, some states have more robust statutes with longer sentences and things like that. Some states have less strict rules. So how is the law applied? I'm going to be talking to you today, telling you a lot of stories about social host law in Massachusetts, how it's enforced. And unfortunately, most of these stories involve tragedies to young people. is the story of Commonwealth versus Neerum. The picture you see there is Brendan Neerum, at the time 19 years old. I believe it was January of 2003 when Mr. Neerum, then a freshman in college at Syracuse University, was home for his Christmas break, and his parents were out. He had 3 of his friends come over. He went up to New Hampshire. He bought a 30-pack of beer, brought it back, and he and his friends consumed that over the course of an afternoon. Early that evening, Mr. Neerum got a call from his mother saying that she was on her way home, and so Mr. Neerum and his friends decided that they needed to get out of there. And so Mr. Neerum got into a car and drove 2 of his other friends away from the house. One of his other friends, though, Billy White, got into his own car, inebriated, and drove away. On his drive away from Mr. Neerum's house, he collided with 2 pedestrians, Neil Bornstein and Trista Zink, killing Trista Zink and causing a severe brain injury to Mr. Bornstein. And so, of course, the police investigated. How did this 19-year-old man get this alcohol? They figured out that he got it from Mr. Neerum. And so in addition to charging Mr. White with DUI, homicide, and DUI causing serious bodily injury, they charged Mr. Neerum under the social host statute for furnishing alcohol to his friend Billy. Mr. Neerum pled guilty. His lawyer no doubt advised him to do so and to rely on the court for some mercy. And these were his comments before the sentencing. He said, at the time my actions seemed harmless, but now I know how terrible the outcome can be. If I only could have stopped Billy, the entire tragedy wouldn't have happened. He was focusing, of course, as most of us do, on preventing drunk driving. And that's what most of us think about when we think about underage drinking and the problems that can happen, the tragedies that can happen. I'm here to tell you that it's not just about taking the car keys away. It's not just about preventing drunk driving. As you'll see in a lot of the stories that I tell you, tragedy follows underage drinking all the time, whether or not the minor is drinking. So Mr. Neerum asked the court for mercy, but the court was not so inclined. And so the judge sentenced Mr. Neerum to 1 year in jail, 6 months to be served. He would actually have to do 6 months. And so Mr. Neerum then, of course, fired his attorney, and he hired a new attorney. And he's asked that attorney to appeal the sentence. And you might be asking yourself, well, how can you do that? He pleaded guilty. Does that make sense? Well, what his attorney argued was that this statute doesn't apply to Mr. Neerum and people like him. After all, Mr. Neerum was 19, his friend Billy was 19. It's not the case of somebody over 21 providing alcohol to a minor. It's somebody the same age, and so he couldn't be found guilty, even though he pleaded guilty. Well, the appeals court was having nothing to do with that, and they upheld the sentence. And what they said was, the language of the statute is the language of the statute, and it says whoever furnishes alcohol to a minor is guilty of the statute. So, of course, that's what the law is today. If you provide alcohol to somebody who's under 21 years of age, you have violated the social host statute. If you are a 15-year-old who supplies alcohol to a 20-year-old, you have violated the social host statute. And of course, if you're older than 21 and you provide alcohol to somebody other than 21, you have also. That's the social host statute as we know it. There are some other statutes that can be used to enforce providing alcohol to minor in rare cases. Manslaughter is one of them, as you probably know. Manslaughter is unlawful killing without malice, without intent, and it carries in Massachusetts up to 20 years in jail. Manslaughter is normally proved through proven gross negligence, wanton or reckless conduct, and you can probably predict, guess how that could be applied in cases of social host liability, and I'll tell you about one such case. This is the story of Alexis Garcia, a beautiful, popular girl who died at the age of 15. Ms. Garcia had a friend, also aged 15, and on that girl's 15th birthday, her father bought her a 20-ounce bottle of vodka. Ms. Garcia and her friend decided to play hooky one afternoon from school. They stayed home, and being novice drinkers, they decided that they would drink that 20-ounce bottle of vodka between the two of them. And they did. And that afternoon, quite inebriated, Ms. Garcia went upstairs to the bathtub, filled it up 3/4 of the way, and she drowned in that bathtub that day. Of course, there was an investigation. Police wanted to know where she got the alcohol. And when they learned that it had been provided to her friend by her friend's father, they charged him with manslaughter. This is Timothy Parent, one of the most ironic last names ever. He was being a terrible parent, that time when he gave that alcohol to his daughter. And he pleaded guilty to manslaughter and was sentenced to 5 years in probation, and was the first recorded case that we're aware of in Massachusetts of somebody being charged with manslaughter in the social host context. So those are the laws that are generally used to, the criminal laws that are generally used to enforce social host liability. And we go around talking to groups like yourself about this, and we get a little bit of pushback. Some of you may feel this way also. And what we're normally told is, in our community, minors drink. And there's nothing that we can do about it. So what we've decided to do is make it safer for them by providing alcohol to them in a safe manner. So it can be a house party for a birthday, a graduation, a holiday party, something like that, the theme goes. And what we're told is, we're going to throw a party, we're going to provide a little bit of alcohol to minors, but we're going to take their keys away so nobody can get hurt. They'll go, they'll drink, maybe downstairs in the basement, they'll sleep it off that night, we'll make them scrambled eggs and French toast in the morning, we'll make sure that they are sober, then we'll give them their keys back and everything will be fine. I hear that all the time. At every one of these kinds of presentations, I hear stories like that. And the rationale is that, of course, it's better to have kids drink in a controlled environment. And the assumption is that behavior and consequences are predictable. Of course, they are not. When minors drink, often for the first time, often to excess, tragedy follows. The reality, of course, is death. And this is one story involving underage drinking in the social host context. No cars involved. Maggie Doug, at the age of 17, from nearby in North Andover, died at one of those very parties in 1997. Ms. Duggan attended a party just like that, drank a lot of alcohol, and during the course of that party tried to take the stairs down to the basement. She tripped down the stairs, fell all the way down, and crushed her skull. Unfortunately, nobody saw this happen, and so Ms. Duggan lay at the bottom of those stairs for hours and hours with nobody knowing that she had been injured. In fact, as other people came down to the basement, they figured that she had just passed out. She had too much to drink, and they left her there. At some point, some of her friends even came and put a blanket over her so that she could sleep it off, not knowing how seriously injured she was. The father, who was hosting the party, who was very close with Maggie, even walked down the stairs. People were kind of stepping over her body as they went downstairs. Nobody knew what was going on until some 6 or 7 hours later, when it was too late, and an ambulance was called, but nothing could be done, and she died. This is the host of the party, Mr. Zarella, and this is exactly, his quotes were exactly like what we hear from parents all over the Commonwealth. Just wanted to have them drink at a safe place. I thought it was safe. It's not always about motor vehicle accidents, and here's one more story to illustrate that. This is a picture, believe it or not, of a 16-year-old boy who died when he bled out. Mr. Berry, Michael Berry, attended a similar party where at a friend's house, the St. Jean house, where Mrs. St. Jean allowed kids to come over and drink at her house. She thought it was a safe place for that to happen. And so she sat there in her family room while a lot of teenagers paraded past her with backpacks and bags full of alcohol, went down to the basement and drank. And that happened night after night after night. One night, Mr. Berry was there. He became very drunk and he became belligerent. And at some point, so belligerent that he was asked to leave the house. He wasn't happy with that, and so on his way out of the house, he punched his wrist through a plate glass window and then ran out. And he wasn't seen for some 30 hours, and eventually his dead body was found 2 or 3 houses down on the front steps. He had gone up. You could follow his blood trail going up the steps of houses trying to get help, but he didn't get it, and he bled out. What happened? Police investigated, found out that Miss St. Jean allowed this to happen at her house, and they charged her under the social host statute. She pleaded guilty, and she did 6 months in jail. I think she was the first person under the social host law to actually do time in jail. So she did that. She left her daughter, at the time 16 years old, hysterical and motherless. It's a tragedy, of course, for the Berry family. It's also a tragedy for the St. Jean family. This is a story not from Massachusetts, but actually from Virginia, where the law is more strict than Massachusetts. But I use it as a good example because in this case, there was no tragedy. Nobody was injured. Nobody died in this case. This is a picture of Alyssa Kelly with her 2 underage children. One of them had a birthday party, a 16th or 17th birthday party, and she bought a lot of alcohol, had his friends come over, and the friends came over, they played a bunch of drinking games, they went to sleep, nobody got hurt, nobody drove drunk. But the police found out about it. I don't know if neighbors complained about the noise. I don't know if other parents complained when they found out that their children had been drinking there. But the police found out, investigated, found out that Ms. Kelly had spent some $374 on alcohol for minors, and they charged her under Virginia's social host statute. And they also charged the boy's stepfather, her husband at the time. And she pleaded guilty, threw herself on the mercy of the court. And the court, she had very bad timing to throw this party because as she was about to be sentenced, there were a lot of problems with underage drinking in her community, and a young child had died from it. And so the judge literally threw the book at her and gave her, I believe, 5 years in jail. Nobody was hurt, nobody was injured. 5 years in jail. It might have been more than that. She appealed it though, and it went up to the appeals court, and the appeals court said, you're right, 5 years is too much, but upheld the sentence and gave her and her husband 27 months in jail to be served, and she served it. You may say that is a little bit strong, and she, of course, would agree. This is an interview done with her from her.
It's very hard sentence. It's very harsh. I don't even fucking take it or anything. I was trying to say it, and I did it. Nothing happened. But then, I just think, she need to close the child for everything that, it's amazing to me that there's so many parties still going on. You see it in the paper, you see it everywhere, and nothing's happening. But I get prosecuted, nothing's happening.
I'm not sure if you could hear that very well. What she says is, she was, first of all, this is the common theme. I was just trying to give them a safe place to drink. But she also says she's the poster child. She is the scapegoat. And I tend to agree with her. 27 months in jail seems far too harsh for providing alcohol to minors on one occasion when nobody was injured. But I use this story to illustrate what can happen We are hearing, as we go around the Commonwealth, from prosecutors and police officers that they are charging more people with these crimes and they're prosecuting more people. And they, like this prosecutor and this judge, are no doubt looking for scapegoats in Massachusetts. So every time you or your child provides alcohol to minors, you're risking being the person who is the scapegoat in your community, the person who the district attorney wants to use as an example. Sometimes they choose somebody who's high profile in the community. Sometimes they do it because there has been a recent tragedy in the community. But every time you or your child does this, you are risking becoming a scapegoat here in Reading or somewhere else around Massachusetts. This is the last story that I'll tell you. I think it really illustrates how the law is applied. This is David Holman, dead at the age of 19 after a car crash in 2007 out in Northampton. Mr. Holman went to a party at one of his friend's houses. His friend was 21 years old and bought alcohol legally. Most of the people at the party were 21 years old and drinking legally. Mr. Holman and some of the other guests were not. The party began in the afternoon. People were playing drinking games. That evening, Mr. Holman's friend's parents came home. They continued to drink with the kids at the party. They even joined in and played drinking games with them. But importantly, they did not buy or supply any of the alcohol. What they did was allow minors to drink along with adults at their house. And so after Mr. Holman's accident, there was an investigation. Police found out what had happened, and they charged all three of the Leskos under the social host statute. They charged Andrew Lesko with buying and supplying the alcohol to Mr. Holman and other minors, and Deborah and Edgar Lesko with allowing it to happen at their house. That is what the social host law says. You cannot allow it at your house, even if you didn't provide it, even if somebody else provided it. And so they pleaded guilty and were sentenced to probation. So that's the criminal law in Massachusetts and how it is enforced. Of course, in addition to the criminal charges against you, even if you're sentenced to community service, even if you're only sentenced to probation and you don't have to do any time in jail, a criminal record will follow you. It's especially difficult for young adults, 18, 19, even younger. For example, this is the common application for college. I'm sure a lot of you are very familiar with this. You are asked on the first year application, have you ever been convicted of a crime? And if the answer is yes, you have to explain yourself. And the same is true when you are applying for a professional license, like a CPA, or to become an attorney. It's true when you are applying to graduate school. All of these applications ask you whether you've been convicted of a crime and then call on you to explain why. And all else equal, if you have been charged with a crime, you will not get that job, you will not get into that school, you'll end up going to a school much lower on your wish list than otherwise, simply because you decided to provide alcohol to a minor. And so it will follow you around for the rest of your life. It has implications, of course, for athletics. A lot of schools have zero tolerance policies. Certainly the MIAA does not allow it. And it also provides that schools can have much more strict policies. In addition to, of course, the loss of life and limb, all of these tragedies, all of the criminal penalties, you're also exposing yourself to enormous civil liability when you allow minors to drink. No matter how safe you think they are at your house or wherever you are exposing yourself to civil liability. I can tell you as a lawyer who works on these kinds of cases, if a minor is injured as a result of an underage drinking accident, that family will almost certainly find its way to a lawyer's office and will almost certainly bring a claim against whoever they can find who has violated the social post statute. Ordinarily, to prove a claim of negligence, you've got to prove duty, breach of that duty, proximate cause, and damages. But in a social post liability, you're able to establish negligence by proving that the person has broken this law. And it's much easier to do than otherwise. This is the case that says it. This is a typical timeline of what you will be exposed to if you are found to have provided alcohol to minors and the authorities find out about it and somebody gets hurt. Typically, criminal charges and civil claims will be brought against you. You can expect a complaint for one or both of those within 3 months. The civil trial will likely, the criminal trial, I should say, will likely be over within a year. But the civil case will drag on and on and on. 3 years at least, with appeals maybe on to 5 years. And you will be forced to think about and explain your decision to allow a minor to drink alcohol over and over and over again. I've worked with families on both sides of cases like this, and I can tell you that because of a stupid decision that you make, it's sometimes just on the spur of the moment. You're exposing yourself to all of these things, and you're really looking forward to 3 or 5 years of absolute misery. So, of course, in addition to the misery that you put yourself through, you're exposing yourself to a civil judgment or a settlement against you. This is the budget for the party that you might throw. You buy some beer, some ice, some cups, and some pizza, which costs you, like Ms. Kelly, about $375, but you're exposing yourself to a civil judgment in the order of $8.6 million, or more or less. But this, I didn't make this number up, I didn't pull this number out of thin air. This is the actual civil judgment in this case. The Commonwealth versus Neerum case. Ms. Zink, who died in that accident, and Mr. Bornstein, who was injured in that accident, brought civil claims. Ms. Zink's estate brought a claim, and Mr. Bornstein brought a claim. And this is a reproduction of the actual verdict sheet. You'll see I'm not sure if you're going to see it here, but this says $8.6 million. Ms. Zink's estate was awarded over $7 million. Mr. Bornstein and his parents $1.6 million. That's the kind of thing you're exposing yourself to. Of course, it could be more. And you may say, well, I'm covered. I have homeowners insurance. In Massachusetts, the typical homeowners coverage is $500,000. Sometimes it's up to $1 million. In very rare cases, there's an umbrella of $3 million or more. But almost nobody has $8 million in coverage these days, and I don't think too many of us have that kind of money sitting around to pay out. The reality is, because of a spur-of-the-moment decision to allow minors to drink alcohol, you may be exposing yourself to liability that will ruin you, that will take everything that you've been saving for decades to earn. So that's what I have to say. I will take questions in a moment. These are the takeaways. In Massachusetts law is clear. 21 years of age is the bright line rule. If you decide to disobey that law, you're exposing yourself. First of all, you're of course exposing children to senseless tragedy and injury. You're exposing yourself to jail and a criminal record. And of course, you may have thrown the $8 million party. So that's the gist of what I have to say. I'm happy to take questions if any of you have them. I really can't see. Nobody has questions. I can tell you all that.